December 16, 2025. The Supreme Court just issued an order list that has gun owners across America asking, "Did we just lose?" The case is Viramontes v. Cook County, a challenge to Cook County. Illinois assault weapons ban that prohibits AR-15s and over 125 other rifles by name. For months, gun rights groups have been pushing this case as the vehicle for the Supreme Court to finally rule on the AR-15 bans nationwide. Justice Brett Kavanaugh promised in June 2024 that the court would address this issue in the next term or two. But today, December 16, 2025, the Supreme Court denied certiorari. They're not taking the case. Does this mean AR-15 bans are constitutional? Does this mean the fight is over? Or is there more to this story than the headlines are telling you? Let me break down exactly what just happened, what it means for AR-15 owners in banned states, and why this might not be the defeat it appears to be. Here's what happened. The Supreme Court released its order list for the December 13th conference. Viramontes v. Cook County case No. 25-238 was listed as "Cert denied." That means the Supreme Court is not taking the case. The Seventh Circuit's decision upholding Cook County's AR-15 ban stands. But here's the critical detail most people are missing. Nitrogen monoxide justices dissented. Not Justice Thomas. Not Justice Alito. Not Justice Gorsuch. Nobody wrote a dissenting opinion saying we should have taken this case. That's significant. When the court denied the Maryland AR-15 ban case, Snope v. Bruen, in June 2024, Justice Thomas wrote a powerful dissent joined by no one. Justice Kavanaugh wrote separately saying the issue needs more time to percolate. But this time? Silence. Complete silence from all 9 justices. What does that mean? It could mean several things. Theory number 1. The case had procedural problems that made it a bad vehicle. Cook County argued the plaintiffs rushed to lose and didn't properly develop the record. Theory number 2, the court wants to wait for a better case. There are other AR-15 ban challenges pending, including Illinois' statewide ban currently at the 7th Circuit. Theory number 3, the court is waiting for more circuit courts to weigh in. Right now, the 1st, 2nd, 4th, and 7th Circuits have ALL upheld assault weapons bans. There's no circuit split yet. Let me explain what led to this moment. 2021. Cuthberto Viramontes, a Cook County resident, along with the Second Amendment Foundation and Firearms Policy Coalition, files lawsuit challenging Cook County's assault weapons ban. Cook County's ordinance, officially called the Blair Holt Assault Weapons Ban, prohibits possession, transfer, and sale of 125 specific rifles including AR-15s, AK-47s, and any semi-automatic rifle with features like pistol grip, folding stock, muzzle brake flash hider, detachable magazine. 2023. While the case is pending, Illinois passes a statewide assault weapons ban. Protect Illinois Communities Act. This overlaps with Cook County's ban. 2024. The 7th Circuit decides Bevis v. Naperville, upholding Illinois' statewide ban. The court rules that AR-15s are too militaristic and therefore not protected by the Second Amendment. The Bevis court said, AR-15s are civilian versions of the M16. They're useful in military service. Therefore, they can be banned. March 2024. The District Court in Viramontes, bound by the 7th Circuit's Bevis precedent, upholds Cook County's ban and grants summary judgment to the county. June 2024. Meanwhile, the Supreme Court denies suit in Snope v. Bruen, Maryland AR-15 ban case. Justice Kavanaugh writes, "In my view, this court should and presumably will address the AR-15 issue soon. In the next term or two." Gun rights groups saw this as a promise. They thought, next term or two equals we have a chance. June 2025. The 7th Circuit affirms the District Court's decision in Viramontes, again relying on Bevis. AR-15s are not protected arms. August 2025. SAF and FPC file petition for a certiorari with the Supreme Court. They argue, this case fulfills Justice Kavanaugh's promise. It's time to address our 15 bans. December 5th, 2025. Case distributed for conference. December 16th, 2025. Supreme Court denies SUT. No dissents. Case over. To understand why gun owners are so frustrated, you need to understand what the Seventh Circuit said about AR-15s. In Bevis v. Naperville, the court created a new test that is not in Heller or Bruen, the useful in military service test. The court said, if a firearm is useful in military service, the government can ban it, even if it's commonly owned by civilians. This directly contradicts Heller, which said the Second Amendment protects arms in common use for lawful purposes. AR-15s are the most popular rifle in America, owned by an estimated 20 to 30 million Americans, Justice Kavanaugh's numbers, or 43 million industry estimates. But the Seventh Circuit said, common use is a slippery concept. Instead, they looked at whether AR-15s are analogous to M16s. They concluded, yes, AR-15s are semi-automatic versions of military rifles. Therefore, they can be banned. Gun rights advocates argue this is wrong for three reasons. 1. It ignores Heller's common use test. Heller said firearms in common use are protected, period. The Seventh Circuit essentially said, we don't care about common use if the gun looks military. 2. It creates a paradox. The Second Amendment protects arms useful for militia service. But the Seventh Circuit says arms useful in military service can be banned. Those are the same thing. 3. It would allow banning almost any firearm. Handguns are used by military and police. Shotguns are used by military. Bolt-action rifles are used by military snipers. Under the Seventh Circuit's logic, all of these could be banned. So why did the Supreme Court refuse to take Veramontes? Remember, it takes 4 justices to grant SUT. Only 4 need to vote yes to hear a case. Based on past votes, we know 3 justices are definitely pro-gun rights. Justice Thomas, wrote Heller, wrote Bruen, dissented in Snoke. Justice Alito, joined Thomas in Snoke dissent. Justice Gorsuch, joined Thomas in Snoke dissent. That's THREE votes. They needed 1 more, the likely candidates. Justice Kavanaugh wrote the next term or 2 statement. Justice Barrett, conservative, pro Second Amendment, but neither voted to grant SUT. Why? Cook County's procedural arguments worked. Cook County argued the plaintiffs rushed to lose. They claimed plaintiffs skipped discovery, didn't submit proper evidence, made procedural errors that forfeited their arguments. Justice Kavanaugh and Barrett may have looked at this and thought, this is a bad vehicle. Let's wait for a cleaner case. The court wants more percolation right now. 4 circuits have addressed AR-15 bans. First Circuit, upheld, Massachusetts. Second Circuit, upheld, New York. Connecticut. Fourth Circuit, upheld, Maryland. Snope case 7th Circuit, upheld, Illinois. Bevis Veramontes 0 circuits have struck down an AR-15 ban. There's no circuit split. Kavanaugh may believe we need a circuit to strike down a ban first. Then we'll have a split to resolve. There's political pressure. Let's be honest. Striking down AR-15 bans would be massively controversial. 10 states plus D.C. have these bans. Millions of Americans support them. Some justices may not want to take on this fight right now, especially with other major gun cases already on the docket. Wolford on Hawaii carry restrictions, Humani on marijuana users. So what does the Veramontes denial mean for you if you own an AR-15? If you live in a banned state, IL CANYNJCT, MD, MA, D, high, WA, the ban stays in effect. The Supreme Court's denial means the Seventh Circuit's decision stands. Cook County can enforce its ban. Illinois can enforce its statewide ban. You cannot buy new AR-15s. The bans remain constitutional under current Seventh Circuit precedent. If you own an unregistered AR-15 in Illinois, you're still in violation of state law, though many sheriffs refuse to enforce. If you live in a free state, watch your state legislature. The Supreme Court's denial could embolden blue states to pass new bans. If 4 circuits uphold bans and SCOTUS won't intervene, why not ban AR-15s? States like Minnesota, Michigan, Oregon, and others may introduce assault weapons ban bills in 2026. The fight is not over. Other AR-15 ban cases are still pending. Illinois statewide ban, Harav, Ravel. Currently at 7th Circuit after Judge McGlynn struck it down in 168-page ruling. Could reach Supreme Court 2026 to 2027. California, Miller v. Bonta. Pending at 9th Circuit. Duncan v. Bonta, magazine ban. Also at 9th Circuit. Could reach SCOTUS. If ANY of these cases creates a circuit split if the 5th Circuit or 6th Circuit strikes down a ban, the Supreme Court will have to intervene. Let's talk about Justice Kavanaugh's statement from June 2024 when the court denied Snope, Maryland case. Kavanaugh wrote, "In my view, this court should and presumably will address the AR-15 issue soon, in the next term or two. Gun owners saw this as a promise. Next term or two equals 2024 to 2025 or 2025 to 2026 terms. We're now in the 2025 to 2026 term. Viramontes was the case that could have fulfilled that promise, but Kavanaugh didn't vote to grant Suck. So either. Theory number 1, Kavanaugh thinks there's a better case coming. The Illinois statewide ban, Haral, has Judge McGlynn's 168-page opinion much stronger record than Viramontes. Theory number 2, Kavanaugh's next term or two means 2026 to 2027 term, not now. Theory number 3, Kavanaugh changed his mind due to political or practical considerations. Gun rights advocates feel betrayed. They thought Kavanaugh's statement was a commitment. Now they're wondering if it was just empty words. Here is something most people don't know. The Trump Department of Justice filed an amicus brief in the Illinois statewide ban case arguing that AR-15 bans are unconstitutional. In the Harrell case, Illinois statewide ban at 7th Circuit, the Trump Doge wrote, AR-15s are in common use by law-abiding citizens for lawful reasons, including self-defense. Once an arm is in common use, its mere possession cannot be infringed. The Trump administration is opposing state AR-15 bans, but they didn't file anything in Viramontes before the Supreme Court denied it. Why? Probably because they saw the procedural problems Cook County raised and didn't want to waste resources on a weak vehicle. But this shows the Trump administration's position. The AR-15s are protected arms. If a better case reaches the Supreme Court, expect the DOJ to file supporting gun owners. So what should AR-15 owners do now? Action number 1. Follow the Harrell case, Illinois statewide ban. This is now the most important AR-15 case in the country. Judge McGlynn's 168-page ruling striking down Illinois ban is pending at the 7th Circuit. If the 7th Circuit reverses and upholds Judge McGlynn, that creates a conflict with Bevis Viramontes. The Supreme Court would have to intervene. Decision expected, mid-2026. Action number 2. Watch for Circuit SPL-IT. The Supreme Court intervenes when circuits disagree. Right now, all circuits uphold bans. But if the 5th Circuit, 6th Circuit, or 8th Circuit strikes down a ban, SCOTUS will take the case. Action number 3. Support gun rights organizations SAF-FPC, GOA, NRA. They're fighting these battles in court. They need funding. These lawsuits cost millions. Action number 4. Prepare for state-level fights. If you're in a free state, watch your legislature. Blue states may try to pass AR-15 bans in 2026 emboldened by Viramontes denial. Contact your state legislators. Make your voice heard. Action number 5. If you're in a ban state, know your law, Illinois. If you didn't register by January 1st, 2024, you're in violation. Many sheriffs won't enforce, but don't advertise what you own. Other ban states. Check your state's specific law. Some have registration, others have grandfather clauses. Action number 6. Don't give up. The fight for AR-15 rights is not over. It's just delayed. The Supreme Court will eventually have to address this issue, especially if Trump DOJ keeps filing briefs supporting gun owners. Here's the bottom line. December 16, 2025 was a disappointment for gun owners. The Supreme Court denied Viramontes v. Cook County without comment. AR-15 bans remain in effect in 10 states plus D.C. The Seventh Circuit's reasoning that AR-15s are too militaristic to be protected stands. But this is not the end. Other cases are pending. The Illinois statewide ban case, Harrell, has a much stronger record. The Trump DOJ is supporting gun owners. And eventually, a circuit court will strike down an AR-15 ban, creating the split the Supreme Court needs to intervene. Justice Kavanaugh said, next term or two, we're still in that window. Maybe the court is waiting for Harrell. Maybe they're waiting for the Fifth Circuit to create a split. Or maybe, and gun owners fear this, the court simply doesn't want to touch this issue. Subscribe and turn on notifications. When the Seventh Circuit rules in Harrell, you'll hear about it here first. Drop a comment. Are you disappointed the Supreme Court didn't take Viramontes? Do you think they'll eventually address AR-15 bans? Share with every gun owner you know. This decision affects millions of Americans. The fight for AR-15 rights continues. It's just taking longer than we hoped. Stay informed, stay ready, and don't give up.